Hi, friends. Welcome back. My name is Carly, and I'm an employment attorney at the Manifest Justice Law Corporation. Today, I'm going to talk to y'all a little bit about the difference between arbitration and mediation. These are two very common processes that happen in employment litigation. And I hear these terms getting mixed up all the time, but they are not interchangeable. These mean very different things. I want to just make a quick video to make sure y'all understand the difference. Okay, so mediation is basically like a sit down negotiation session. Both sides will come together and they will hire a neutral third party it has to be agreed on by both sides. Usually, typically, both sides will share the cost of the mediator. They'll split it down the middle. And it's really just, again, like a negotiation session. So if you are having the mediation in person, it can be a conference room or like some office building, but basically you go in and maybe you all will meet together at the same initially, and the mediator might try to hear both sides out and then mediate together. But typically what will happen is that the parties will go there into separate rooms and the mediator will kind of go back and forth between each room, and she'll go to one party, or the mediator will go to one side and they'll listen to what they say and then give some feedback and be like, well, this is what I think as a response. But let me go take it to the other side, see what they say. She'll take it to the other side. They'll talk to the other side and say, this is what they said. This is what they said. And the other side will respond. They'll hear that response. The mediator will hear that response. And then the mediator will go back to the other room and they'll tell the other room, like, this is what they just said. And so they go back and forth, and it's in hopes of reaching a settlement agreement. And so hopefully there's some kind of an offer made during that mediation session. Sometimes no offer is made. Sometimes an offer is made. Sometimes a case is actually settled. In any event, you learn a lot during those sessions, so they're always great to attend. And if the other side is ever trying to offer mediation and then you don't want it for some reason, I would ask why. Because again, these are always learning opportunities, so they're always good to go to, but they aren't binding. They're not required unless it's ordered by a judge. But it's literally just both sides trying to come together and negotiate and settle the case. If they're not able to, we walk away and the case pursues and it moves to the next step. Arbitration, on the other hand, is required, is binding, is like 100%. So arbitration typically occurs because there's an arbitration agreement or term in your original employment contract. So if you look at your employment contract, if you read through right now, you may or may not have an arbitration clause in there. Right before that paragraph, it'll say something about arbitration. Arbitration clauses can be waived. They ought to be able to be waived. If not, that's alarming. That's concerning. That's a problem. But typically, your employer will give you an opportunity to waive the arbitration agreement. But typically, folks don't know what, you know, an arbitration agreement is. And so we don't waive it. We just sign it as part of the employment contract and forget about it. And we move on and we start our jobs. But an arbitration agreement basically says it's basically you waiving your rights to a trial, and is saying that if you have any legal problems, or if you want to pursue a lawsuit, if you feel like you've had a violation from this company, then instead of suing the company, you will ask for an arbitrator and you will go to arbitration with the company. And then the arbitrator is, again, it's the arbitrator still a neutral third party who's hired, agreed upon by both parties, and there are fees involved. Sometimes the arbitration agreement will say that the employer will cover the fees. Other times the employee has to cover it. Sometimes it's split down the middle. It really depends on the terms and the actual language of your arbitration agreement, but there's still a neutral third party. But in this situation, when they come together and they're hearing both sides and they're trying to negotiate, it's not a negotiation. They're trying to get all of the information so that they can have the arbitrator. They want all of the information. They want to have a full picture and understanding of this case. They want to see some evidence. They want to hear all of the arguments. And then they're going to make a decision. And they're going to say, okay, based off of what I've heard today or this week, this is what this case is worth. This is what you're going to pay. And that decision, whatever the arbitrator says, goes. It's not like mediation where it's a negotiation session and it's a learning opportunity. Arbitration is binding. That's the arbitrator becomes the judge. You have waived your right to a trial and the arbitrator becomes the judge. The reason why this is harmful for workers and employees is because you're waiving your right to a trial. So an arbitrator is someone it's a professional role, so they do it day in, day out. They are hearing cases and they are weighing the evidence and they're listening to arguments. And it's really, really easy for arbitrators because they are exposed to so much trauma and like bad shit that they get jaded. They become cold, and it's really, really easy for arbitrators to undervalue a case because again, they see these situations all the time. They get a little bit numb and they become a little bit jaded from their like ethical and moral compass. A jury, on the other hand, this may be their only time hearing an employment suit or their only time hearing a car accident case. It may be the first time that they've ever been to court. So the sympathy and the humanization that a jury or a juror member is able to afford and to like grant to the parties is typically way more than an arbitrator. An arbitrator is going to be a little bit more buttoned up. It's going to be a little bit colder. They're going to be a little bit more focused on like the bottom line and getting this done and getting on to the next case versus a jury member, a juror who is sitting there. This is the only time that they are going to be here in this court. They have paused their normal life to come be here and focus on you. Maybe there's a little bit of distraction or resentment for that. But in general, they're pretty devoted and focused and honed in on what's going on in this case. It's only one case that they're focusing on. And they have a lot more sympathy for the parties and like what's going on. So it's just some things to consider. If you see an arbitration agreement in your employment contract, always waive it. Always say, "No, I do not consent to this. I don't wanna sign this. Like, where can I waive this part of the contract?" It's not required that you sign an arbitration agreement to be hired. And if you were hired, and then if a company hired you and then you don't wanna sign the arbitration agreement, and then they decide they don't wanna hire you anymore, that could potentially be considered retaliation. You guys let me know if I did or didn't do a good job on this video. If you found this video was helpful and it helped you better understand the difference between arbitration and mediation, fantastic. Thank you. Give me a like, give me a share. Let me know in the comments that this was helpful for you. If this video was not helpful or not clear or didn't make sense or inspired more questions from you, then please feel free. Drop it in the comments. Let me know. If this was a bad video, I'll make it again and I'll try to do a better job at explaining. And if this was a good video but just inspired additional questions, let me know. Ask the questions in the comments and I'll make you a video answer response as soon as I get the chance. Hope you have a beautiful day. I hope you're walking away feeling a lot more informed, empowered, and like you're going to get paid. I just want you guys to remember everyone works, but not everyone is safe at work. And I'm trying to make sure y'all know the difference. Okay. Have a good day. Talk to you later. Bye.